is not to win, but maybe to have your client convicted of a lesser included criminal offense rather than the one that is the major charge, or if you are defending someone in a claim for monetary compensation, the best you might hope for is that you're still going to have have your client make some payment to the plaintiff, but you hope to make it maybe 50% of what the claim is, or a third of what the claimed amount is. So when we asked people what their goals were in terms of what they predicted was realistic for them to achieve, we took into account that they might be representing people in many different situations where winning, as it is regarded in terms of being the prevailing party, was not the objective. Okay? So, what we have found in legal communication, as in other areas, is that overconfidence generally is quite a robust finding in different professional samples. And some of the professions that have been studied in comparison with lawyers might include accountants, for example, or weather forecasters who have to make predictions every day or several times a day. And you find that there are differences by profession in terms of this phenomenon. So accountants, for example, tend to be underconfident rather than overconfident on the spectrum. So it's not inevitable that professional judgments will be overconfident. Weather forecasters usually get fairly rapid feedback based on the particular predictions that they make, even though they have no individual control over whether the weather is going to rain or be windy or whatever, but there's feedback in a rapid space of time, and so they tend to be better calibrated, we say, or better adjusted, more accurate. In other words, their predictions are not as far off as are predictions of some other professions. So it's important to look at the kind of context in which professional judgments are made in determining whether the overconfidence phenomenon is actually going to be manifest. And so legal communication is an interesting arena to look at because there is a slide that I want to jump to here. There's quite a lot of discussion that perhaps lawyers are in general more pessimistic than optimistic about their work. And if you were moving towards making predictions within a more pessimistic frame of reference, then you might expect that lawyers would be more underconfident about achieving their objectives. So one thing to think about as we consider translating some of the research and findings that I've introduced you to different legal contexts or legal communities is to just think about whether the members of your profession in general in the arena are, on the whole, more pessimistic or more optimistic. There's reason to think that maybe lawyers are more pessimistic because they're always considering what might be the worst possible outcomes. Your job as a practitioner is often to imagine the worst alternative on behalf of your client and to try to build in contract provisions or to build in different safeguards, that address those negative, pessimistically oriented outcomes. And does that frame of reference within which you work then lead you to be more pessimistic or more optimistic in general? I think I do want to find this list here about some other questions that I think it's helpful to consider. Aside from just the pessimism-optimism dimension, and I think you need to consider whether there are advantages or disadvantages to either of those orientations for lawyers. What's at stake if you're very pessimistic and you are underconfident versus what's at stake if you are very optimistic and are overconfident in your predictions. but does that have something to do with whether lawyers are risk averse or risk taking? So do you think that in general lawyers are more risk averse or more risk taking as a group?
Risk takers. Risk takers.
Risk takers, okay. And why would you think that?
In a given particular situation, lawyer need to defend his client.
In a given particular situation, a lawyer has to defend his client, and he's also, it's a probability. He may get the judgment in his favor, or he may not. So, I assume a lawyer is a risk taker.
All right, so, and when you talk about defending the client there, are you thinking about civil or criminal defense?
Criminal defense. It's a job of a lawyer to see that his client is not being punished and comes scot-free from the situation.
Sure. And so if you see a criminal defense lawyer as more inclined to be risk-taking, would you expect them to be more optimistic or more pessimistic in making predictions?
Optimistic.
Optimistic, right. So we have, one prediction that criminal defense lawyers, compared to, say, other lawyers, are going to be more optimistic in general in looking at the possible outcomes. So we'll see how that fits, how that view fits with some of the data that we gathered, though not from this context, of course. All right, are there any people in the class who think that lawyers are more risk-averse than risk-taking? Yeah.
I think lawyers are, there's a lot at stake here. It's not just the client, it's also their own reputation.
I think lawyers are more risk averse because it is not just the client, it's also their own reputation. Unlike management professionals whose work is more collaborative, lawyering, at least I'm a non-lawyer, but to me it looks like a very individualistic activity. So as a profession, so I see lawyers as more risk averse, and because they are more risk averse, they weigh the facts, they weigh the conditions in which, and I have a criminal lawyer in mind. I think even a civil lawyer would do the same thing. So they must be weighing the facts, they must be weighing the kind of judge who comes on such cases. A whole lot of other factors come in before they decide to take over the case or not. So when it comes to the confidence component, I think they're not going to be optimistic, they're going to be pessimistic about it. Because they have to see the negatives first before decision making happens.
All right. So, I think there's merit to both sets of arguments, and so I'm going to, ask you to just note down for yourself which camp you think you fall into and for which area of law as we go forward and look at the kind of data that we produced on this question. So do consider whether you think there are differences in the way that civil versus criminal lawyers might approach the issue of risk on behalf of what's at stake for them as professionals or what's at stake for their clients. Do you think that they're the same? We've tended to focus in both of the examples that were given on criminal law. So what about civil law? Think of any reasons why civil lawyers might behave differently than criminal lawyers in representing their clients? In your civil system, do lawyers represent clients on a contingent fee basis in civil cases?
Sometimes.
Sometimes, okay. Do you think that might make a difference? If you're a lawyer and you've got to undertake, risk because you're paid only on a contingent fee basis, do you recover anything if you don't prevail in securing the goals that you have on behalf of your client?
I was wanting to sort of answer to your and see what happens, especially in civil litigation in India, is that very often just the litigation has a way of the fact that there is an ongoing litigation, and if you've been able to, say, obtain a stay on an adverse order to you, then the continuance of the stay is sufficient as far as what the client requires from you. So therein, it's more a case of you're strategizing in a manner. You're not really moving to decision, but you're moving more towards just holding the fort.
Right, so if your goal on behalf of your client is to get a stay on behalf of your client and you achieve it, then that in terms of this study would be that you have succeeded in achieving your outcome. And the question that I'm asking people to consider is whether they think that for civil lawyers in general, they would behave very similarly to criminal lawyers or differently in terms of whether they are more risk averse or risk taking. And maybe there is no difference in your experience, but I think do keep thinking about that question as we go through these data. What I'm suggesting is that, for example, for plaintiffs' lawyers who are taking matters on a contingent fee basis, where they don't recover anything in terms of costs of the case or whatever later on, unless they prevail on behalf of their client, they have an enormous amount at stake compared to a defense lawyer, who doesn't get to choose which cases he or she undertakes, and who simply represents a client, or not in the frame that is already set by the plaintiff's lawyer. So they're usually retained only after the plaintiff's lawyer has kicked off the case and filed papers and set it in motion. So they're in a reactive rather than a proactive position in terms of assessing the risks of the case, and what sort of difference might that make to whether they're going to be more risk-taking or more risk-averse, and who has more at stake. Does the defense lawyer in the civil case get paid no matter what, and the plaintiff's lawyer gets paid only if they prevail? And how does that affect the different ways that they might assess the outcomes that they want to achieve on behalf of their clients? So, those are some issues that might lead to differences in their behavior. And similarly, if we compare prosecutors and criminal defense lawyers, would we think that what is at stake for them is very similar or not? So consider those. So what about judgments by men versus women in the law? Traditionally, the law has been a male-dominated profession. If you look at the demographic of most law school classes today, it's very female-dominated in most countries. And so there's a tremendous shift in the demographic balance of male versus female attorneys in most countries. And that places some emphasis on the issue to which men versus women lawyers are well calibrated. So one of the questions to go forward on is whether you think that there are any gender differences in professional performance. Do you think that women or men are inclined to be more pessimistic or more optimistic? And, you know, I'm not asking you to stand up and tell us what you think at that point, but you might just, you know, note down your own concerns and predictions about that before we go forward with these data. What about the role of experience? Would you expect a new lawyer who's newly qualified to be as, or to behave similarly in making risky predictions or risk-averse, risk-taking decisions compared to someone who's been practicing for 15 or 20 years? Would you expect there to be differences in the way that they approach the prediction task?
Yeah.
Yes? So that?
Yeah, there's been a lot of study, at least in India, in the law and society framework, for example, on repeat players, what Mark Gallagher calls repeat players. Now, the tendency for lawyers who have been practicing the same court over a longish period, they have shown they've demonstrated a capability to predict outcomes better, or at the least know how to game the system in some way or the other. Because it's a stratified society and the structure of courts in India is also extremely leans towards privileged older men. There's a tendency to recognize and acknowledge experience in courtrooms also. And that plays a role in how you present a case before a particular judge, how you play the docket system to make sure your cases don't or do turn up, depending on where you are. So I do think experience, or at least just being there for a long time, plays a role.
Okay. Well, I think you're talking about two kinds of experience there. You're talking about specialization. You know, in one sense, you alluded to people who have worked in a particular arena and gained expertise in that arena, and then you've also talked a bit about just being there, or you know, having a number of years of service or years of practice, and so those might lead to different kinds of predictions. If you were a generalist, you might not have exactly the same special expertise as someone who's a specialist in a particular area of law. And in fact, what you're suggesting was borne out in a study of lawyers' predictions done in the Netherlands by Marika Malsch and colleagues, where, you know, it's an inquisitorial system as opposed to an adversarial system. But what they found there was that the lawyers who had the specialized training and were making predictions in their area of specialty were well calibrated. So clearly, their experience honed their ability to make better predictions about the outcomes they could achieve, and they did achieve those outcomes. And when those two match, we call them well calibrated. Okay? So the other issue, though, on who are generalists, the Dutch study found the generalists did not necessarily have the same degree of calibration. So simply years of experience alone seemed to lead to some different outcomes. Okay? So that's another variable to consider as we go through and look at these data. All right, so back to this slide here, where, you know, I think a couple of other points that are worth emphasizing are that where a task is seen as more easy, people behave differently than when a task is complex or difficult.
I'm sorry, but I had a question.
Go ahead.
I was wondering whether the concept of confidence, the concept of confidence is now confounded with the concept of competence. Lawyer competence.
Sure.
If you start breaking up, is there a confounding that's happening? Because when my colleague was talking about the study that happened here, the idea of repeat players, how do you segregate or how do you control confidence or break it up from competence?
Well, that's an important question, and it's a difficult issue to control in many studies. where, you know, because having objective measures of competence in law is, you know, itself a complex construct. You know, just the same as measuring competence in many domains, you know, is a multifaceted kind of dimension to address. And certainly in the study that I asked you to read, there was no control at all for degree of competence. So you could, as you're suggesting, have a situation where somebody might have many years of experience but continue to be incompetent. And you know, there is no inevitability that in fact years of experience is correlated positively with competence. So, but that's slightly different than just the issue of confidence. Okay, so confidence is a separate dimension than competence. And so in the study that I asked you to read, there was no separate measure of competence per se. Okay? But the issue that we're looking at when we ask people about how confident they are is related to whether they're achieving their own goals, which is the way that we framed the outcome variable, because if they were setting their own goals rather than some other objective standard being imposed on whether or not their goals were realistic or whether they were competent in choosing them, would have been a very difficult set of data to obtain and marshal, especially, you know, since in the sample that we're going to describe, you know, we had just lawyers coming from a multiple range of different states and different areas of practice, so there was no way to include those kinds of controls. But you know, that's an important distinction to make and an important question as we go forward and look at these data. So thank you. Okay, all right. So what I wanted to highlight was that the perception of the task difficulty also affects people's predictions. You know, so if you think that a task is going to be very difficult, then you usually have a different level of confidence, and what I've noted there is people tend to overestimate their ability to achieve it, whereas when it's very simple, actually they tend to underestimate by comparison. When the likelihood of achieving the goal, or the probability of achieving the outcome that they've chosen is higher, that also tends to increase the overestimation. So those are some findings from some other data with other measures of other participants that simply led to some of the background going forward into this particular study of a lawyer sample. And the other dot points on the slide here about appropriate and inappropriate confidence are just to ask you to think about some of the practical issues that might apply. So appropriate levels of confidence when someone is well calibrated might lead them to make better decisions, for example, about whether to accept an offer, a plea bargain, or a settlement offer, which they might otherwise reject if they had an inappropriate confidence level. You know, if you are either too confident or too underconfident, then you're constantly going to make what might be suboptimal choices in terms of your own professional judgment or on behalf of your client. So those are some of the risks associated with not being a well-calibrated lawyer. So now I'll talk a little bit about the research procedures that were followed in this case, and I realized this was quite a challenging reading to give you because this was a standard psychological report rather than a piece of legal writing. And so I just wanted to highlight for you that most primary research reports have 4 sections. They always have 4 sections, as did this one. So there's an introduction that talks about the literature review and background and research questions. Then there's a method, and we're about to talk about the method. Then there are, you know, the bold results from the methodology, which are not mixed up with the interpretation of them, because the interpretation comes in the 4th and final section, which is the discussion section, So this was a way that I wanted to introduce you to some primary research reports so that you could get a sense of what it might look like and what it might feel like having to read something a little bit out of your comfort zone. I realized that there were quite a few statistical outputs in the middle of that article. I want to make sure that you realize that the p-values were the most important parts of the statistical information that was presented in that article. So when we presented some of the outputs, we talked about the means or the averages. So there are usually three kinds of average measures in research reports: means, medians, and modes. And sort of the general average is often called the mean, and so that's indicated with a capital M. And then next to that, you might have seen the letters SD. That stands for the standard deviation, which is usually how much variability there was in the group around that particular measure. So, you know, if the average measure of confidence for a group of lawyers was 50, and there was a standard deviation of 10 or 15, that tells you how big a group there was around 50. And when there is a low standard deviation, that means that everything is clustered very tightly around the mean. When there's a very large standard deviation, it means that the responses of the participants were spread quite widely, right? So that's what the SD stands for. The p-values that were associated with the statistical tests just reflect the convention in most social science to assess whether or not something occurred by chance alone, or whether something else occurred. So if it occurred by chance alone, there would be no real interest in it. So we're interested in results that violate that principle, those that did not occur by chance alone, because that shows that there is some causal relationship or something different in the groups that we're measuring. And we usually have a 95% confidence interval. So we allow a 5% error margin in making those assessments. And the way that that is translated into a p-value is with the designation that any p-values that are 0.05 or smaller, because that's the threshold of 95%, would be statistically significant. So when you look at those reports and you see the p-values, if they're very small, under 0.05, that's an indication that there was a significant difference between the experimental group and the non-experimental group. Whether we were comparing plaintiffs' lawyers and criminal lawyers, or whether we were comparing those who had the intervention or didn't. When you have very tiny p-values, that's what grabs our attention. When the p-values are over 0.5, it means that is not a statistically significant finding. Okay? Nowadays, it's also a convention in many research reports to include an effect size as well as a p-value, and I think this report did not include those, so you would not have seen those as well. But there's a lot of interest today in including some other measure, aside from a p-value, of the strength of the finding, so that you can tell which are the more robust or the less robust findings. Okay? So that's just to help you interpret a little bit what some of the italicized material was in between all of the prose. So I want to make sure that you're comfortable with those. Okay, so now on to a little more about the research procedure itself. So we did the study in two parts. The first part was very onerous because we wanted to sample lawyers in a very thorough and diverse way so that there were fewer threats of biases in who participated in our group, so that we could get more reliable data. So we secured participants from continuing legal education seminars of different types. We also used phone lists that we obtained from bar associations and randomly sampled people's names and sent them invitations to participate, and then phoned them as opposed to approaching them in person at a continuing legal education seminar. And all of them were asked the same set of questions. They were asked to think of a case that they were personally handling that was going to come to some finality within the next 2 to 6 months. And that was our window of opportunity to assess their predictions. So some of them were making predictions maybe 6 months away from a possible trial date or a possible other threshold of finality. And others might be making their predictions within 2 months of that time frame. So there was some variability in when they made the prediction compared to when the outcome was anticipated. Then, to preserve the confidentiality of the lawyers and their clients, we asked them to generate a secret name for their case that they would recognize if we contacted them in 7 or 8 months to ask them about the case. And so they made up code names, which we recorded. And then we asked them, well, what we did then was our experimental manipulation. We did ask them what the minimum goal was first that they were seeking to achieve on behalf of their clients. So there was a self-defined, self-generated outcome for the reasons that I explained earlier, not a win-lose proposition. Then half of the participants were in our experimental group where we asked them to generate reasons why they may not achieve that goal. This is a standard de-biasing technique to try to reduce overconfidence. Half of them did not get that intervention, and they simply went on with the next question in the study and did not generate reasons before responding to our key question, which is, what is the probability or likelihood that you will achieve that goal on a scale of 0 to 100%? And the lawyers had no trouble coming up with percentages. That's quite common, that people think of make their future predictions in terms of percentages, and so that wasn't a difficult issue for the practitioners. All right, for those who were in our in-person data collection, we did not want them to contaminate the data collection by reading all of the questions that they had on a sheet in front of them about generating reasons they might not achieve the goal. So some of them gave no reasons because we had no way of knowing in what order they had read the questions on the piece of paper in front of them, which was quite small. And if people had read about generating reasons why they might not achieve a goal and then gave their prediction, we wouldn't necessarily know that. So some of them actually gave no reasons, some gave reasons before, and some gave reasons after. Right, then we waited and waited. And then we had a follow-up by contacting our participants, after 6 months to find out what happened. And we asked them, gave them the code name for the case, asked them what had happened. In some situations we lost people because there'd be no finality yet, so they dropped out of the study. In other situations they moved on and changed firms and we could never find them. We lost them. In some cases we mailed things after them and still could never track them down. We learned how mobile lawyers really are in this process. And at the end we had about, I think, 447 people that we tracked in our study period. And they were asked whether they thought they had achieved their goal. We knew what they'd said their initial goal was. We asked them what the outcome was and exactly when it had occurred so that we knew the time lapse between the prediction and the outcome. Okay, and then we were able to do our analyses following that of their degree of calibration. And I'm going to start just by separating for this point now, the civil and the criminal practitioners, because in what you've already read, there is a section that provides some of the overall data on how well calibrated they were among them. Okay, so clearly some of the lawyers were well calibrated in different groups, but let's focus on their area of practice. So there were a smaller number of criminal law practitioners than civil practitioners in our sample. just by happenstance. And there were somewhat more prosecutors and defense bar members. And in looking at the kinds of cases that they had, we wanted to classify those to see whether there are any patterns about prediction, forecast, success related to the case type. And we found that when we split those in the criminal arena, there were about 2/3 that we classified as crimes against a person and 2/3 that were either crimes against property or victimless types of crimes. Overall, the criminal lawyers, mean confidence was about 63%. And overall, as a group, they were somewhat overconfident because fewer achieved their goals. And they did have, therefore, the traditional overconfidence bias rather than being well-calibrated or underconfident. But when we looked more closely at those data, we saw that the criminal defense practitioners were the ones who were boosting the numbers towards overconfidence, and that the prosecutors were better calibrated on the whole as a group. And there were differences in the crimes as well. So the property crimes and the victimless crimes led to better calibration than did any of the crimes against persons. So there was something that was just less predictable in general about the nature of those kinds of cases than some of the other kinds of cases. Better calibration again there came from the prosecutors rather than the defense bar. They tended to think that they would achieve goals that they were unable to achieve at the end of the day. So the defense lawyers were not doing as well as their prosecutorial counterparts on the whole. So think about some of your comments earlier about what you were predicting in terms of the risks on behalf of the criminal defense bar and what they were facing and how that might play out. Subjective impressions about their success, we were surprised to learn across the board, tended to exceed what the reality of the success was. When we looked at what people thought they had achieved versus what they told us actually was the outcome, and both of those were self-reported, we saw that they generally gave themselves a lot more positive assessments in achieving their goals than we did, coding them more objectively. And so that seemed to indicate that there was some sort of post hoc, self-serving positivity in assessing their own performance, even if they hadn't clearly achieved those goals.
I was just wondering that because criminal defense lawyers are faced up with situations of people losing life or liberty, and hence to exude that kind of confidence is possibly a driver for them to improve everything. Not just in terms of getting a client, but in believing in the cause and going forward, it's important to be generating that kind of positivity.
Absolutely, lawyers have to be zealous advocates on behalf of their clients, and so there is a need professionally to appear confident, and perhaps you need to keep that kind of optimism in mind in order to continue with your job as well. So there are a number of mechanisms that really might lead to that sort of overestimation.
It's generally said that if you don't believe in your own case, then how can you get another to believe? And after all, as a lawyer, or to convince a judge or a jury, so it's all the more necessary that you require some level of overcompensating possibly.
I think that's very likely, and I do think, even if you look at the code of ethics for most lawyers, they are encouraged to be zealous advocates on behalf of their clients, and that seems to require a certain mindset. So that may play into it. Okay, so how did our civil practitioners do by comparison? This was a larger group with roughly even plaintiffs versus defense lawyers in terms of the cases that they cited. Of course, some lawyers might change sides from time to time, but In this sample, and certainly in the US context, there tends to be more of a clear divide between plaintiffs and defense lawyers in the civil arena. I don't know what the case of that practice is here. Australian practitioners seem to move around, the roles and arenas quite frequently, and so the delineations of these groups in this study that might be general to their practice might only be very case specific if you were to replicate the study in a slightly different legal context, and so that's something to think about too in terms of how you might rate the applicability of some of these findings to your legal context. Do lawyers tend to undertake multiple roles in multiple types of legal fora, moving from civil to criminal, plaintiff to defendant, etc., and sometimes even maybe taking on cases on behalf of the prosecution, as do Australian barristers quite regularly. All right, so what we saw was that there were no general differences in their likelihood or predictions, probabilities of achieving their goal between plaintiffs and defense lawyers civilly. Very close numbers. If you look at those diagrams or graphs, the figures that are in the research report, when you look at the data, what you're looking for is some indication about the slope of the line. So a perfect calibration would have a slope of number 1. And variation from that indicates some variation from perfect calibration. So if there is a positive slope as opposed to a negative slope, that shows that the lawyers can distinguish to some degree the cases where they achieve their goal from those where they don't. The smaller numbers way down further away from 1 show that they're less successful in making that distinction. So that information may also help you interpret some of the data that are in that report. On the whole, though, we found much more overconfidence than underconfidence because there weren't that many individuals who made predictions that the likelihood of achieving their goal for their client was under 50%. Yes?
In this situation, can we take that the difference between the confidence level and the goal that is set, the gap can be a deciding factor whether it is confidence or overconfidence?
The gap could be underconfidence as well as overconfidence, how much they vary. So what we saw was that when people made low predictions in general, under 50%, they were mostly susceptible to an underconfidence bias. And when they made predictions that were over 50%, they were more prone to be susceptible to an overconfidence bias.
Because when they were asked the reasons for their failure, they were not in a position to, they were blaming the other variables, other extraneous factors. That shows the level of confidence, whether it was confidence or it is very easy to, with an intellectual mind, to defend whether it is confidence or it's overconfidence or whether it is competence, and there are many other aspects to it. But the gap between the goal that you set with the level of confidence, and then without blaming the extraneous factors, accepting the failure, or accepting the overconfidence level. Can we take something like that?
What we had understood as well, of course, is that the lawyers, like other people, tend to be subject to what you call an illusion of control. They think that they have more control perhaps over these situations than they do in reality, because of course there are other extraneous factors that influence the outcome of cases that they did not take into account when they made their predictions. So at the end of the day, when we did some in-depth analysis of the reasons that they provided as to why they wouldn't achieve their outcome, and also when we did that part 2 phase, we asked them when we were discussing whether they had achieved their goals, if they hadn't, what they thought were the major reasons that they hadn't achieved their goals. In those situations, of course, they were, retrospectively providing explanations for why they weren't achieved, as opposed to the experimental portion where they were predicting reasons why they might not achieve them. In the retrospective analysis, there was much more concession that certain things that were outside of their control played an important role in changing the outcomes from what they had predicted. There was more, or let's just say less awareness of the extent to which external factors might intercede when they made those initial predictions. So that tends to show more that illusion of control that is often associated with professional decision making in the course of the job.
And one of the reasons could be because the training that the lawyers get throughout the tenure, throughout their education system.
To do? Which sort of training?
That they feel more confident about what they're going to do. Based on the decisions, previous decisions, based on their own experience, based on their own judgments.
Right. I mean, it's clear that as a profession, from these data, lawyers erred on the side of overconfidence in general rather than underconfidence. So we could say that in general, we learned that lawyers were very over-optimistic. Whether that's, particularly from training or from just the demands of the job is a little more difficult to say precisely. It could be caused by a number of factors.
And maybe they're not aware of whether they're overconfident, only with the study that they have come to know that the study is revealing so many facts.
Right. But I can't say definitively that their training did it or didn't, because we didn't test that. We didn't have specific training that people got or didn't get to see what that impact was. But that's the kind of study that could be done. You could, if you were interested in assessing what leads to particular professional attitudes, you can certainly run a study where you give people certain training or don't, and compare, or run a correlational kind of study where you look at the training that is undertaken, the amount of it, and then see the degree of correlational strength with some other behavior. So those can be assessed. Yes, was there a comment over there?
My question was, I was thinking if there's this.
I was actually struggling with some part of the text, and I was not able to break down overconfidence into what it was being measured as. One. That's my first question. Overconfidence is a construct, and my colleague who just brought in another word called confidence. So how has the construct of overconfidence been broken away from confidence? To answer that question, I wanted to see what was being measured as confidence, what was being measured as overconfidence. That doesn't come through the reading. I was not able to find out that.
We asked them what was the likelihood. We didn't ask them how confident are you, because we weren't interested in just subjective statements about how confident they felt. So we were not measuring directly with our participants an assessment of how confident. That wasn't what they were asked. But in terms of the construct that we're reporting on, the way that we have defined overconfidence, and I'm not speaking about confidence generally in this study, I'm speaking about overconfidence or underconfidence, those are operationally derived measures in the way they're defined.
As what, madam? Operationally defined as what?
Their predictions of their success.
Okay. Now, when it came
They're they're variations in numbers from the outcome. So if somebody said, I am going to get my client, convicted of a lesser included offense, than the charge of homicide, and then and I say, how likely are you to achieve that goal? And they think about it and they say, well, 75%. Okay, they're giving me an estimate, just of likelihood. Then we come back in phase 2 and we say, what happened in your trial? And they say, well, my client got so many years for homicide, not the lesser included offense. That would be a disparity between the goal that was set and the outcome. And so we would rate that person's prediction then as overconfident because they were unable to achieve the goal that they had established. So the word overconfidence, as I'm using it, is really only going to be applied when there is a gap in the direction, where a higher number is given than was achieved in a group. And if somebody is overconfident, if they had said, oh, I think I've got a 35% chance of achieving it, and in fact they achieved it, then I would rate them as underconfident. Okay, so that's how we define it. So there's no other definitional discussion about the construct of overconfidence. It's really quite mathematical.
And very outcome connected. It's
outcome
prediction
connected.
of their outcomes is the way which you are assessing it.
Yes.
So the way I understood it is not like that you're constructing a confident or an underconfident or an overconfident lawyer. You're more asking them questions on their work and saying, okay, how do you predict what is going to happen? That's the way I comprehended it.
That's right. So we're not having any discussion with the lawyers at all about their competence or their confidence at all. Under, over, or anything in between. Okay.
I think some of the references that have been given explaining what confidence and overconfidence and underconfidence is, they have quoted. Maybe those studies are explaining what it is. But here it is not regarding exceptionally with regard to the confidence. How confident and how overconfidence affects is more important in this particular study. They have referred in the first or second paragraph itself, they have given the references of what this term actually means. So maybe in those studies we can.
Right. We followed the convention in this area of research in general. But I think those are really valuable questions. And I do appreciate them, because I don't want there to be confusion about subjective confidence in general, and the notion that we discuss that with our participants. Okay. All right. So I think we've sort of covered those main findings, and I wanted to jump to the plaintiffs versus the defense lawyers. But let's take your question.
I just wanted to know what is this? Where's the mic? Really quickly. I just wanted to know.
Must still be turned off. Okay. Again.
It is on.
Hello. Really quickly, I just wanted to know what was the slope in this study? That's my first question. And the second question is, does the slope which indicates the ability of civil lawyers to discriminate between successful cases and non-successful cases, is that ability linked to overconfidence? And in this study, not a lot of civil lawyers were overconfident. Like the slide said, they were under 50%. Thank you.
Sure. Okay. Without having those pictures here in front of you, it's a little difficult to just talk to you about the slope. So the way that you can plot a slope is sort of by looking at what might be an average line between the dots, okay? So we've provided you in each of those figures the perfect calibration line, which would be just the diagonal, and the extent to which the line that would be drawn through the other dots varies from that would be the slope for a particular group. So I'll have to follow up with you and look at the particular picture there to really respond to your question in more detail about the slope for particular groups there. I think we did report on this slide over here some of the data about the plaintiffs and the defense lawyers' slope. What we indicated there was that the plaintiffs and the defense lawyers were not identical. There was a slight advantage to the plaintiffs' lawyers compared to the defense lawyers. And, and since those individuals in this context were more likely representing their clients on contingent fee bases than were the defense lawyers, that might be one reason that they were more astute or sensitive to or focused on distinguishing cases that they had the choice of taking or not, and then in determining whether they would be successful or unsuccessful. Because if you have the right to refuse that case, you might reject those where you didn't think that you had a chance of achieving success on behalf of your client. So those numbers said, in that case, the capital P and capital D stand for plaintiff and defense lawyer. It's the italicized lowercase g, P, that is the probability estimate, which is not on any of these slides. Okay? The interesting finding, though, about the plaintiff's lawyers is that they were also more overconfident than the defense lawyers in the civil arena. So it was very surprising that they were not better calibrated in terms of just overconfidence. And in thinking about this, because I was quite baffled by that result when we first got it, I wasn't sure what to make of it. I mean, I thought that the plaintiff's lawyers would not only be better in discriminating successful and unsuccessful cases, but also would be less overconfident or underconfident in general, but they weren't. Some of the other data that we followed up with to try to tease apart this issue helped to answer that question a little more when we saw that there wasn't a really dramatic shift in some of the plaintiffs' assessments, whether they made them earlier or later in time. We will look at the time data, which was not necessarily all in the paper that you reviewed. I'm going to show you some extra data on that. But I realized that what seemed to be going on was that they must have made a probability assessment when they first interviewed their clients, and then they committed to that, and they didn't really waver from it, even as more information came their way as the investigation and the case unfolded and the trial date approached. They did not shift their calibration or adjust their probability estimates in a way that you might have anticipated. So they assessed the cases accurately in that sense at the outset, but their estimates of their success were off.
I suppose this will again get connected by the fact that if the plaintiffs are coming with contingent fees, then they need to believe in that case. And I think this need to believe in the case is kind of very significantly controlling how the prediction of success seems to be happening. And I'm kind of proceeding more from, that very underlying kind of advice you're constantly given, that if you're advocating a cause, not just a case, but you're advocating a cause, it's important that you believe in it and you exude it. And you find very often that you meet with people who kind of are so very believing of that cause that they tend to carry people with them. And that's what means, and occasionally, of course, it also sort of is counterproductive, because the very fact that you are so passionate about what you're believing in, kind of gets the other person to become that much the more careful, and hence not believe. You know, if you take it as just generic roles, I would somewhere believe that a defense lawyer needs it that much more in criminal law, and the plaintiff lawyer who's coming in on a contingent fees arrangement needs it that much more in civil. So, I mean, your findings, and I'm not sort of saying it totally on, if you had to just give it out as that, okay, go out there and do it, this would kind of be in accordance with that sort of.
And I think that's reflected further in the fact that in the North American legal community, when there is a crossover in the kinds of cases that lawyers undertake, you often find that it is the plaintiff's lawyers who do some criminal defense work. That's where there seems to be that sort of, a similar mindset or advocacy orientation that is very compatible. So that fits very nicely with the explanation that you offered. So anyway, so that was interesting in terms of, the consistent overconfidence that we saw more with the plaintiff's lawyers. Okay, so now this was just a follow-up study with a master's student and lawyer, Steve Teller, who's still practicing law now in Seattle, who did his work just on some of the more refined timing associated with the predictions using this data set. And this was to try to understand whether the time in relation to which you make your assessments of likelihood leads to better or worse calibration. So what we did in this case was we divided our sample into two groups, those who made their predictions further away, 3 months or more from the date of expected resolution, and those who were closer in time to the resolution, which was usually trial. And then, we looked at the slopes again, and we saw that nearer the trial did have a better fit. And those that were further away were doing worse in terms of their ability to discern whether they would achieve the goals on behalf of their clients or not. So clearly, timing was really important. And you could, imagine that as time passed, more discovery was done, and the pressure of getting ready for trial approached, people were interviewing more witnesses, etc. They had much more information at hand in order to inform the kinds of likelihood estimates that they made. And so the database from which they were working had shifted compared to those who might have been making predictions when they were not yet really engrossed in the case, compared to those who were really preparing for that resolution period. We did see that overconfidence itself also dropped as the predictions were made much closer in time. So people were better calibrated further on. All right, so what did we think were some of the reasons? I've mentioned the discovery. We've also mentioned, particularly with the plaintiff's lawyers, their autonomy in choosing their cases, and the contingent fee I've emphasized a number of times, so won't go over that again. All right, so we're reaching a point where I wanted to do was outline the exercise that I'd like you to be undertaking, and we'll take a break, and then when we return from the break, I'm going to give you some concerted time to work together on a series of questions to try to look at the implications of some of the findings that we've been discussing about lawyers' performance. There are a few that were in the article that I haven't re-emphasized now, such as we did find that the women were generally better calibrated than their male counterparts. Although when the women lawyers gave high estimates of the likelihood of achieving their goals, they were also susceptible to overconfidence. But in general, fewer of them fell into that category than among their male counterpart lawyers. And another important finding that I haven't emphasized now was the role of experience. And in our sample, we found that when we looked at lawyers who had 10 years of experience or more and compared them with lawyers who had less than 10 years of experience, there was absolutely no difference in their calibration. And so we were compelled to conclude that in this sample, experience alone might be leading people to become or to remain more overconfident, but they did not, as we thought, improve, though we didn't have refined data on the extent to which the case about which they had chosen to discuss in the study was one in their area of specialization or was out of their area of specialization at all. So we couldn't refine the experience data based on anything further other than number of years in practice as a proxy for expertise. So those were quite perplexing findings, and we landed up having to conclude that perhaps people who've been doing something for a long time simply think they're better at it just by virtue of the number of years they've been doing it, particularly in the case of lawyers because they don't get feedback from anyone in a regular and formal sense about how they're doing. It's unlike the weather forecasters. The time in lawyers' practice to get feedback is quite limited. Whether you prevail or don't in a trial, as we've started to unpack, is influenced by a number of external factors that you can't control. So even if you have terrifically acute ability to be well calibrated, you might still not prevail. You can't necessarily use that as a feedback outcome. And so how do lawyers go about getting feedback? And all of the research on these sorts of psychological biases points to the real importance of constant feedback in lieu of training or as a form of training to better refine your ability to discern whether you have a chance of being successful if that is the goal or in choosing a more appropriate goal. So that was, a possible explanation within the North American legal system for this particular interesting finding that was counterintuitive entirely. Okay, so for the task that I would like you to undertake, I want you to consider implications in various areas. And as I indicated, in psychology and law, we always talk about implications of studies for future research, where clear gaps and limitations of studies are identified or other research questions might pop up. Implications for practice, and we've had a lot of focus today on the practice end of things, but also implications for policy making, which is much more in the consideration of psychology of the law in this regard than perhaps some of the other dimensions might be. And in addition, what I'd like you to do in considering each of those topics is to consider them from different perspectives of people who have different roles in the justice system. So consider perhaps what the policy implications might be if you're looking at it from the standpoint of a judge or an arbitrator or a mediator, someone in a third-party position. The standpoint of the lawyers for whichever sector, for the clients for whichever sector, and for the justice system at large. And I think that and then I think we can break it down further. We could look at, all of these implications in different arenas of law, like implications for corporate law, implications for criminal law, implications, for tort law, implications perhaps for ADR practice, because unless we start to unpack it in different ways like this, the study will remain abstract and you won't necessarily have a chance to see what some of the uptake might be for those of you who are trying to look at it in your legal context. So the way for us to divide this up, you can't all do all of this in the short bit of time that I'm going to give you to think through these issues. I think what we'll need to do is arrange to have certain groups look at practice, certain at policy, certain at research. All can do it from these different perspectives, but we might want to assign you also to do it from those 4 different areas of law in particular, so that when we finish group discussion on that, we can then combine the results by having people from those different groups report back and come up here and discuss these further. Okay, so I think it's a good time for us to take a break.
If I could just add on one more thing, especially because we're going for break and if they're going to wrap their head around it. It may also be worthwhile for us to look at the sort of study and data that we've done in how it could translate into our kind of context, in the sense of if we are speaking in terms of maybe say better calibrated predictions from lawyers. What exactly does this mean systemically in somebody practicing in India? Maybe something which can be kept in mind as each of these are being looked at. It's an additional challenge, but I think unless we do that, it could just be that you do it more in a, where you understand the concept, but its larger practical effectiveness doesn't come in the same sharp way. So I would sort of also urge that if we take that in as much as is possible, in the sense not overly to complicate and totally set it aside, but I do think that would need to be taken into account if we want to take this further from here.
Right. No, please do. So I think that will give us probably about 12 groups. So when we come back, I'll try to make 12 little tags or something and then get you into about at least 12 groups or so for us to have a more focused discussion within each group before we get people to report back to the class as a whole. Right, but how long a break shall we take?
You can
Take half an hour break in this hour?
Because we have another hour and a half after
Yeah.
we come back. So we're just replacing this with the Saturday class.
All right, okay, so 30 minutes, you're free to talk about it now, and then we'll give you some groups and some time to discuss it when we reconvene. Okay. Is that what you're thinking?
No, because this is the tea break time.
Okay, good. Okay, all set. Thank you. so let's do it. Okay. All right. Yes, of course.
So I was wondering if you spare us the time, maybe we could have like say a 40-minute session organized by the committee for the students who are not in the course as to like the relevance of law or psychology. Because like this is something we keep doing through entire training sessions on campus, going through how important it is, you know, when you're going for maybe a competition or practicing it, that like, you know, you're very careful with like what psychological assumptions you're making about the other party, things like that. Your psychological frame of mind, how you're going, how it changes when you're in a pressure situation. So if you could like release this 40-45 minutes.
Okay. I'll have to just check with Professor Danda with, you know, but let's take it up with her and see how to work it. I mean, it would have been, you know, helpful if they kind of come today or something.
That's right, yeah.
I know, but you know, I'm obviously interested in it.
Yeah.
So
the problem is this course is not open to the first and second years.
right.
So like they're missing out on a lot of things.
Okay, let's have a chat with her about the okay? And, you know, if we can, I will.
Thank you.
Okay, all right. Okay.
It's very difficult. It is not that easy to understand something. You have to have that unless and until you have it also shows the results.